Welcome back. I'm your host, Attorney Michael Potter, and today we're going to be discussing the Revocable Living Trust Estate Plan, a basic level estate plan that everyone should have. One of the questions that I often get asked as I speak around the country at various workshops and conferences is, what's the difference between a will and a living trust? And it really boils down to the use of the probate court. It's unfortunate, but in the United States, most people die without a will. And whether you have a will or not, it is the probate court of the county where you are domiciled that takes jurisdiction and authority over the estate of people who have passed away. Probate is the legal process of administering your estate, paying for the bills, handling the taxes, assessing who should receive the assets, and then making distributions in a way that protects those assets from simply being invaded and taken by people to whom you don't want them to go. Now, at least if you pass away with a last will and testament, at least you have established who you want to get the assets. And you appoint someone to be the executor or personal representative of you in the probate court so that the assets pass down to the people that you want, rather than having relatives and friends and strangers just show up at your house and start taking assets just because they want them. That may not be who you want to get those assets. So at least with a probate and a will, you have designated who you want to receive your assets after your passing. Now, normally, the probate process, whether you die with a will or without a will, it takes some time because it needs to be handled in an orderly fashion. At least with a will, you have decided who will get your assets rather than state law. If you haven't written a will, state law will determine who gets those assets, not you. At least with a living trust, you avoid that whole process in the first place. What if you haven't died, but you are medically incapacitated to the point that you can't handle your own financial affairs anymore? Maybe you're in a coma for a number of years. Who would take over then? It's not your relatives, it's not your friends, it's whoever the court appoints. And that's why it's so important to have planning in advance so this doesn't happen to you. Now, the nice thing is that with a living trust, you avoid that whole mess. Your assets are able to pass to the people you want them to go to without the interference of a court or outside attorneys or strangers or people making claims against the estate. It just very quietly, very privately passes ownership over to the intended heirs in the way that you want it to go. Now, with a living trust, you are the person who establishes it. And under legal language, that is called the grantor, the person who establishes the living trust. That's going to be you. Now, you select the beneficiaries of the trust. Normally, that's going to be you as long as you live. When you eventually pass away, or if you're married, if both spouses have passed away, now the people that you've designated will become the new beneficiaries upon your death. Now, one of the things that's really nice about the living trust is that you can specify that the beneficiaries who receive the assets of the living trust following your eventual death will receive it as their own sole and separate property. And I've done that with my own children just in case they get divorced. I want to protect those assets from being part of any divorce settlement, and I would rather that my children have those assets alone and that it not go to either my future ex-son-in-law or my future ex-daughter-in-law. I want it to go to my kids, and so will you. The next thing you're going to do within the living trust estate plan is to pick a trustee. Now, it would be wise to pick someone who's likely to outlive you. So unless your parents are really young, I wouldn't pick your parents. I'd pick maybe your best friend, maybe one of your children, maybe your sibling, a brother or a sister, or an aunt or uncle, or a cousin, or a friend. Someone that you think you can rely on who has the personal integrity to follow your instructions. Now, the living trust is one of a handful of trusts where you can be your own trustee. In other words, once the living trust is established and assets are transferred to it, you manage your everyday financial and property affairs just as you always have. You're the trustee. And in the event something happens to you and you're married, well, your spouse could continue to serve as trustee. If you're single and something happens to you, then your successor trustee can step in. And it's at that point the trustee would begin to do their job other than you. Now, when I work with clients to establish their living trust, I usually ask them to pick 2 or 3 successor trustees. That first one should be your top number 1 choice. And if something happens to that person, then you'd have a second choice and a third choice that could always be a backup in case something happens to your first choice. But the job of that trustee is to follow the instructions that you've put into the living trust. So choose someone carefully. Choose someone who has the integrity that you can rely on, and then pick a backup, a second or third choice, just in case. Now, I don't know about you, but I'm a big believer in gradual inheritance. I like the idea of assets passing down to your intended heirs in a gradual way so that, frankly, they don't blow the money so soon. In other words, if they get a little bit at age 25, and then another portion at, say, age 30, and then the rest at 35 or 40 or 50, whatever age you choose, that avoids the problem of what I like to call affluenza, where they get the money too soon and they blow it. It's gone. With gradual inheritance, then they get something that gives them an immediate benefit, but the money that they won't get until maybe 5 years later or 10 years later is something that will grow over time as it's accumulating. And then by the time they're a little older and more mature, they'll appreciate it when they get that next distribution at, say, 5 years later or 10 years later. It's grown over time. Let's say it's in an account earning, 7% interest. Well, in 10 years, it's going to double. So you can see that if they don't get the money too soon, but they inherit it gradually, they have more maturity and the money has grown over time. And to me, that's a much better way to inherit through the living trust. Now, in this slide, you can see exactly how the living trust of a single person would pass. The assets of that person are put into the living trust. They are the trustee as long as they live. And then upon their eventual death, the assets can pass to their heirs with the successor trustee stepping in and making the distribution exactly as you want. And of course, this is how it would look for a married couple, where the assets of the husband and wife can be kept separately if they were inherited or earned prior to marriage. And any joint assets that are accumulated after the date of marriage, they can go into the living trust along with separate property assets, which will be held under a separate schedule. And then upon the death of the first spouse, there is no probate at all. The surviving spouse continues on as a trustee until that spouse's death, and then the successor trustee that you've chosen would step in and make distributions according to your instructions. Now, a properly drafted living trust estate plan would have the living trust as the centerpiece of the plan. It would be the centerpiece. However, there would be additional or collateral documents that would also typically be included in a well-crafted living trust estate plan, like a pour-over will, which catches anything that may be left outside of the trust on the date of death and pours it over into the trust for distribution. It might also include the power of attorney for health care, a generalized power of attorney for financial matters. It might include the Advanced Healthcare Directive, or sometimes called the Directive to Physicians on Artificial Life Support, and other documents such as trustees' instructions and so forth. These are all typically part of a well-crafted estate plan. In addition to these collateral documents, such as the pour-over will and the powers of attorney for health care and so forth, it's also good to include a couple of other items, and I just want to briefly mention them here. The personal property memorandum. Those might be things that maybe don't have much of a financial value, but they have a strong sentimental value, such as the family photo albums of all your vacations and places that you've been, trips that you've taken, and the kids growing up, that kind of thing. It might also include items that you want to give to selected other family members, maybe your grandmother's wedding ring, or a special memento like a piece of artwork or that type of thing. That would typically be handled by the personal property memorandum that would be attached to the living trust and be incorporated into it by reference. And you know, I like the idea of leaving to your children or to the guardians for your children or the successor trustees a memorandum. It might be a written memorandum, it might be a video that you leave to them with some instructions on how you want your children raised by the legal guardians, or your hopes and dreams for your children. I had a client years ago who left some very nice videos for each of his 5 children, in which he described to them his best memories of them as little toddlers, how cute they were, and all the fun things that they did together. And then he ended each video for each of his children with encouragement to be the best that they could be, to reach inside of them for the best of their core values, to live a life that's worth living, and to hold his memory as a testament to what he had tried to do as a father. I was very touched to tears by those videos, and I know his children were too. Now, is that a legal document? No. It's just a nice thing to do as a parent. And if you think about it, it would be nice to have that your trustee could then pass on to your children, and they could view those videos after you're gone. Nice touch. Very classy. In our next video in this series, we're going to talk about what the living trust can own. And that will be very important because everything that's owned by the living trust is intended to escape probate or conservatorship. And those things that are not in the living trust will be subject to the probate jurisdiction of the court. So, I'll see you next time when we look at what the trust can own. I'm attorney Michael Potter. I hope you're enjoying this series, and I'll see you next time. I look forward to hearing from you.